Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Well, good morning, everyone. Today is Tuesday again at 10 a.m. Pacific time here on the Bottled Business Sense show. This episode today is our last one for 2018, and I was looking back at our blog website, and we've been actually doing this for about 4 years. June, I believe, of next year will be we'll have completed our 5th year of providing all these educational videos from a legal business standpoint, asset protection, as well as marketing and video marketing tips. So hopefully you've enjoyed it over the years. If you're new to the show, welcome. There's a whole host of videos that you can look at on our website, and you can find us at bottledbusinesssenseshow.com. We're all over social media on Facebook, Twitter, YouTube, and Google+. So I'm sure there's something of interest for everyone out there. If you are in need of these types of topics, take a look at our blog, and you can find a library of information. So before I bring Bill onto the show today, we're going to speak. Bill's going to talk on employment termination in California, and let's just get right into it. Welcome to the show, Bill. Hope you're doing well today.
Thanks, Rick. Appreciate it. And as a little year-end message, we don't profess to be big-time celebrities or radio hosts or anything like that, but we bring this to you for free in hopes that you'll enjoy it, but more specifically in hopes that you'll get some information out of it. And so look at that from that objective window when you decide to listen or watch our videos. I would also add that because of certain state requirements, if you do contact me by way of email or phone call after the show concerning any one of our shows or any issue that you may have, I will have to establish an attorney-client relationship with you before I just go ahead and give you advice. That can be explored in more depth when and if you contact me, and I'm sure you'll understand that once it's explained to you in a little more detail. I'm also going to write up a little notation to that effect and provide it to Rick so he can put it on our YouTube website and our Bottle Business Sense show website for you to be able to take a gander at it. With that said, Rick, before we get into this show, which is going to be called Employment Termination in California, where else can they get a hold of us? I know we got YouTube, we got Bottle Business Sense show, we got my website, wfblegalconsulting.com, where the show can be watched. What other places do we have?
Oh, absolutely. You can find links to these episodes on Facebook, Twitter, and Google+. So anywhere on social media, pretty much, you can find us. I believe Bill also has links via his LinkedIn profile. So take a look at that feed as well.
Okay. So I've titled this, this is an overview of employment termination in California. Each of these things I'm going to talk about has a more in-depth topic attached to it, which you can watch on other videos that we've already done or contact me personally about. But the first thing you must understand is employment termination in California is the show's title because I want people from an employment standpoint and from an employer standpoint to objectively look at what I'm going to speak about and evaluate it in that manner because it's important to both the employee and the employer. First of all, if there's going to be a termination, in California, make sure you decide whether there will be, in fact, a termination or a layoff. If you're going to lay somebody off, you're essentially eliminating that position. Okay. And you should have policies and practices within your company that decide for you or help you decide when it is you're going to do that. If you terminate somebody, that's a whole different ballgame. You are terminating somebody, but you're going to fill that position with somebody else, presumably. So let's talk about termination now that we've distinguished between termination and layoffs. First of all, the general rule in California is that employment is at will in California, meaning you could be fired for any reason at any time or for no reason whatsoever. What are the exceptions to that general rule? Well, if you have a contract with your employer at the time you're hired, a written contract that states specifically what the just cause or reasonable cause is that would constitute reason for your termination, then only those reasons laid out in the contract can be the cause for your termination. It overrides the at-will relationship. Likewise, if you're in a union and you have a collective bargaining agreement, that collective bargaining agreement will outline how you can be fired. If you are going to terminate somebody, make sure you look at your company's policies. They may be progressive in nature. You may have a progressive disciplinary policy. And that's why I've spoken to you before about how important it is to have an employee handbook for employers and employees to be able to have that handbook. Progressive discipline would be something like this. You complain to the supervisor, advises you of a written or verbal warning. You now want to appeal it up to a higher level or his supervisor. You may have a situation where you first get a verbal warning, then a written warning, then you're terminated. So both internal policies on how the levels progress and who you may see in those different levels are all part of the internal progressive disciplinary policies that your company may or may not have. I would suggest that you do have those in your company handbook. Next, determine by a review of the employee's file whether you have sufficient reason to terminate them, assuming there's no contract, because you want to make sure you're not violating any state or federal laws. What are those discrimination laws? They would be national origin, age, race, religion, gender, physical disability, sexual orientation or preference. The Americans with Disabilities Act, you are required to give somebody a reasonable accommodation if it doesn't affect your business to the extent that it might not allow your business to go forward in a profitable manner. This discrimination, which would include firing somebody because they're pregnant. All of these things I've outlined within the discrimination realm are both mandated by federal law under Title VII and under California law under the California Fair Employment and Housing Act, which mirrors federal law under Title VII. Next, do not fire somebody because of workers' compensation issues. You have to have the workers' compensation insurance that's mandated in California if you're a California employer. Do not fire somebody in violation of public policy. What do I mean by that? You don't fire somebody for retaliation reasons. If they report to you a violation of statute, ordinance, regulation, or they report to you something that someone else is doing and you fire them because of that, then typically that's called retaliation. You can sue for that. So those are the legal ramifications of terminating somebody and making sure you have all the bases filled. Remember, when you terminate somebody, do these three things. If you've come to the conclusion that you can legally terminate this person, do these three things. Number one, you must give them their final paycheck on the final day of their employment. You must. By California Labor Code, it's required by law. Make sure you have them sign a document indicating they will provide you back all of the employer's property, if indeed they have property, which would include proprietary property or proprietary information, I should say. And finally, keep it short and sweet. Indicate to the employer that, the employee, it's no longer in the best interest of the company to continue the employment relationship, unquote. keep it short and sweet. So to recap, let's make sure that we are, I think I lost the picture there for a second, but we're back. Let's make sure that we distinguish between termination and layoff. Make sure that you understand the at-will employment relationship in California that exists if there's no contract. If there is a contract, you must follow those policies and procedures. If you have policies and procedures in place requiring progressive discipline, that needs to be followed, whether there's an at-will relationship or a contract situation. Make sure you have a review of the personnel file in place so you know you're not violating any laws of discrimination or retaliation. Make sure that you pay the terminated employee, if you do decide to terminate he or she, their last paycheck on the last day of employment. Keep it short and sweet and tell them their employment relationship is no longer working, and make sure you receive and get in return back any property that you have provided the employee. That's it in a nutshell. All of these include overlapping issues of a great involvement. So you need to have a business attorney on board to discuss these issues if, in fact, you have any clouded views, or if, in fact, you are not sure about one of these particular areas that you need to delve in more clearly to ensure that you're not violating any laws, i.e., the discrimination laws in California and under federal law. So I hope that helps as an overview. And I hope you put that in practice in a general sort of a way to make sure you're following all of these steps. Okay.
That's awesome. Thank you very much, Bill, for the overview and great information. And folks, if you have any need on this topic to speak more in depth about it, you can obviously reach out to Bill. Bill, what's the best way for our audience to get a hold of you?
Well, phone numbers are 949 area code 413-6535. And the other number, I believe, is 698-6222, also 949 area code. Bill at wfblegalconsulting.com is my email. And, of course, you can find my websites, wfblegalconsulting.com, PYE365.com, which is the estate planning website. And I believe there's also a employment website that you can find as a link to my general website. And again, all within the realm of business lawyering is the establishing of asset protection by way of a business entity for the employer, making sure that an estate plan is put in place for their private personal assets for the family, and making sure that the employment relationship is taken care of in protecting employees, making sure employees are aware of what their rights and obligations are, as well as the employer, so that no litigation arises. Because what have we said from the beginning of this show almost 4.5 years ago? Yeah. We want to keep you off of the courthouse steps if at all possible, right?
That's right. Well, thanks again, Bill. Yeah, thanks again, Bill, for this great episode. Reach out to Bill. His contact information is right below this video, if you didn't happen to write it down. So give him a ring if you have the need. And with that,
we'll see everybody. We'll see everybody after the first of the year, right?
Absolutely. Happy holidays, Merry Christmas, and everyone have a happy New Year.
Okay, same here. Take care, everybody. Bye-bye.